The prosecuting attorney is the chief law enforcement official of the county. But how does a prosecutor do what he or she does? We'll talk about the prosecuting attorney right now on the Law Works.
From West Virginia Public Broadcasting.
Closed captioning for the Law Works is made possible by a grant from the Monongalia County Bar Association to support legal information and education for all West Virginians. The Law Works is made possible by a major grant from the West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and legal system, promoting public knowledge of the law in West Virginia. By the generous support of Software Systems Incorporated, a West Virginia company established in 1975, providing high-end support services, programming, and consulting for county government AS400 mid-range computer systems, as well as PC-based systems. And by viewers like you.
The role and function of a prosecuting attorney is not typically well understood. My guest is the prosecuting attorney of Marion County, West Virginia, Patrick N. Wilson. Pat, thanks for joining us.
My pleasure to be here.
First question, I guess, is the basic question. How does one get to be a prosecuting attorney?
Well, every county has an elected prosecutor, so it's an elected position, and one needs to make that decision and go through the process.
Partisan election?
Yes.
You have a staff of attorneys that work for you, though.
Yes.
How many do you have on your staff?
In our office, we have 6 full-time prosecutors and 2 part-time.
And the assistants are referred to as assistant prosecuting attorneys.
Yes.
What do you do?
Well, we generally have responsibilities in a lot of areas. I mean, we are responsible in the county for all of the prosecution of misdemeanor and felony cases. In Marion County, that's about 2,000 to 3,000 misdemeanors a year and several hundred felony cases. But there's other things we do. We're responsible for all juvenile delinquency as well as abuse and neglect prosecutions. We also represent various entities in the county. For example, the county commission, sometimes the Board of Education, sometimes other elected officials. So it's sort of a primarily criminal practice, obviously, with some civil components to it.
So it is a law firm in the sense that we think of law firms.
Absolutely, yes.
You have support staff. Where are your offices located?
We're in downtown Fairmont. We used to be in the courthouse, and then the staff got a little bigger and the room got a little less. So the county commission has provided us a new facility basically across the street from the courthouse.
Okay, let's talk about the criminal law. When people think of prosecutors, they think of the prosecution of crimes. Now, the police are the ones who go out and investigate and do the legwork. Does your office get involved in that directly?
We do. It's our philosophy that it's helpful if we're basically as much as we can be from the ground zero from a case. There's so many we can't always do that, of course, but we try to be involved from the earliest stages of investigations throughout the process till the trial process is over.
Well, you talked about the difference between misdemeanor cases and felony cases. Can you briefly tell us what those cases are, how they're different?
Sure. Misdemeanor cases are generally considered to be the less serious of the two. The maximum punishment is normally up to a year in a regional jail facility. The felony cases are what we generally think of as the much more serious crimes, the murder, rape, robbery, those kinds of things, which carry a potential penitentiary sentence with them.
So misdemeanors are the minor crimes unless you're the victim of the crime, in which case it seems like a pretty major affair.
Absolutely, and of course in those types of misdemeanors, we're talking about DUI, we're talking about battery, domestic battery. So even though they're misdemeanors, they're still very serious to the victims.
The punishments just basically are less. The defining difference is the amount of time and the type of facility you spend your incarceration in, if you're convicted.
Yes. Mm-hmm.
You probably don't get involved in the investigation much of misdemeanor cases, do you?
No. Generally, the charging decisions in the misdemeanor cases are what the police officers do while they're out on the street, basically. And there's so many of them that it's almost impossible. We do get calls from time to time for advice about particular misdemeanor cases. But you're right, the majority of them are not something we're directly involved in at the outset.
What is your relationship with the police?
Well, it needs to be, and I think is, a close working relationship. The police officers, and of course we have state police, county police, city police in various municipalities in Marion County. It's a close working relationship, and I believe that it has to be that because of the nature of the evidence gathering, the actual work on the trial preparation, and the actual trial itself.
When typically do you first have contact with the police in a case?
In the felony cases, as I said, there will be several times they'll call us even before charging decisions are made. And we'll talk with them. We may have a need to give advice about search warrants before even a charge is made. Generally, bringing them all together, a defendant that's been charged and the police officers, typically in the felony cases, the preliminary hearing, which is about 10 days after the arrest.
I worked as an assistant prosecutor for several years some time back, and I remember getting phone calls at 3 o'clock in the morning and that sort of thing where the police officer would say, here's what we observed, here's what we know happened, here's what people are telling us. What do you want us to do next? Mm-hmm. You get those calls.
Yes, and as a matter of fact, we've even instituted basically a 24/7 on-call. We always have someone in our office who is on call to take those calls from the police officers. Typically, we get several a day, or at least in the night during the week.
That's interesting because you're in a position of knowing what you want in the courtroom, but you're not particularly trained, or are you, to know how to investigate a case from the police officer's point of view?
No, absolutely. Other than what I've learned on the job over the years, I'm not the one to be out there on the street doing the investigation per se. I've watched a lot of great officers do a lot of great work, though, over the years.
I typically try to avoid the cop and lawyer shows that are on television because I want to yell at the TV screen sometimes. Mm-hmm. That's not the way to do it. But especially the program Law and Order in its various flavors do seem to depict pretty well the relationship between the police and the prosecuting attorneys.
I think so. I mean, there's always going to be times when there's disagreements also, and I think you see those typically on the shows too, perhaps about a particular approach to a case or particular evidence or how that evidence is being gathered. I think they are fairly representative of the real world.
And that kind of brings up the point, sometimes you have to say to the police officer or to the victim of a crime, because it's pretty easy to tell that a crime has been committed. What is often difficult to tell is who exactly it was that committed the crime and what's the degree of the offense, because there are so many things that go into that. How do you tell a police officer or a victim that this is just not a case that you have any chance of successfully prosecuting?
It's a tough position to be in, and unfortunately that does happen more than I like to see it happen. We're stuck with the fact, of course, that there are certain elements for every crime that we're responsible to prove to a jury if we go that far beyond a reasonable doubt. And in several cases, unfortunately, we can see, based upon the evidence, that there may not be a particular element that's going to be met, or, because of that, it's just not going to be something that's prosecutable. My approach to it, and I think a lot of prosecutors that I've talked to would agree, you be honest with the person. You sit down with them, you give them the time to explain it to them, talk to them about why this can't be a particular case that's going to be pursued, and answer their questions and give them the time to explain that.
When you refer to elements, what are you talking about?
Each crime that's prosecutable under the laws in West Virginia requires certain particular things to be proven regarding that particular case. For example, if it were a first-degree murder case, we have to prove not only that someone was killed, but we have to prove that who the person was that did it, of course, and also that that person did it with premeditation. as opposed to maybe it being a spur of the moment kind of act.
By premeditation, you mean that they reflected on it and decided to commit a murder, a killing?
Yes, sir. Yes, and we have to be able to prove that by the evidence that we have in order to pursue that particular level of charge.
And you have to prove, in your case, that crime was committed in Marion County.
Of course, yes.
And sometimes that's not particularly easy to prove.
It's not, and actually there are certain times when people will commit crimes basically literally right on the county line, and it becomes a real issue.
I was involved in one several years ago where the victim, it was a murder case, the victim was last seen alive in Pennsylvania. Next seen dead in West Virginia. Now the question arises, was this a kidnapping case and then a murder was committed? Or was it a murder case and then the body was transported somewhere else and dumped, because that's what happened? In one case, you would try the murder case in Pennsylvania. In the other, you might try a kidnapping case in Pennsylvania, but you try a murder case in West Virginia. And fortunately, in that case, we had a witness who heard a gunshot in West Virginia in the general area where the body was found, and the jury was able to find and to believe that the victim had been shot at least once in West Virginia. There were all kinds of nuance to that, but sometimes those problems can be staggeringly complex to resolve, and there may be no beyond a reasonable doubt resolution of them.
And the fact that in all the criminal prosecutions, all 12 of the jurors have to be firmly convinced of any of those particular elements. So in your example, if only one of those jurors was not convinced of the jurisdictional issues, then that's a problem for the prosecution.
We're talking about the role and function of a prosecuting attorney. My guest is Attorney Patrick N. Wilson, the prosecuting attorney of Marion County, West Virginia. I'm Dan Ringer, and this is The Law Works. Well, the standard of proof beyond a reasonable doubt, that's a pretty difficult standard to meet.
I think it is, and actually referring back to something you mentioned earlier, I think all the TV shows now with the CSI and the other type shows where they're showing about all the technology and the things that theoretically or supposedly are available to prosecutors in the courtroom has made juries really even tougher and more expectant of those kinds of things whenever they hear a case.
Well, DNA tests take about 30 minutes now?
I wish they did. And that is, that hits the nail right on the head. In West Virginia, we have basically one primary outlet to do our evidence testing, which is the West Virginia State Police Laboratory, and they do a great job, but that's for the entire state. And there's great backlogs because there's just a limit of manpower to do that testing.
Even something as relatively routine as an autopsy can take several days to have performed.
Oh, absolutely. And then further, the bigger problem can be several months before we actually are able to get the formal report.
Well, are you talking about toxicology reports, that is, reports about drugs in the victim's system, or just getting the report from the autopsy prepared?
Actually, just getting the prepared report from the autopsy can take several months from time to time to get those. It's backlogged again.
I was looking at your webpage on the internet. You'll find a link to it at our website. You said one of the things that your office strives to do is to provide a speedy trial for the defendant. Getting those kinds of reports back would interfere with having a speedy trial.
It does, and we are, from time to time put in the position of where we have to call down and talk with the people at the lab and try to get a little priority put on particular cases, because it can. And if you have the defense attorneys who are wanting to exercise that right for their clients, it can become a real issue in many cases.
The law in West Virginia is that you are entitled to a trial how fast?
Well, basically, if we indict, we have 3 grand jury terms a year. Our last was just in October, so just a few weeks ago, we had our grand jury. If a defendant wants his trial this term, which would be between October and February, he's entitled to it.
So if the grand jury in the beginning of the month of February says, okay, we're going to charge you with a crime, that defendant has the right to say, I want my trial by The end of December, is that?
Basically, but before the next term of grand jury, which would be February.
February.
Yes.
So by the end of January.
Yes. Mm-hmm.
And you have to be prepared to do that.
Yes, sir.
That's pretty fast, especially in a serious criminal case.
It can be a real issue to have to jump around to get everything ready. Yes.
Well, okay, let's talk about how these cases flow through the system. A police officer calls you typically at 4 a.m. on a Saturday morning or something like that and says, here's the issue that we have. You talk about it, you decide, yeah, there's a crime here, and you ask him to do certain things to document the crime, to gather the preliminary evidence. And so within a couple of business days, you get a report on your desk that says, here's what we know. What's the next step?
Well, particularly in the serious felony cases that we talked about, we try to review those, meet with the officers if we can, talk about what's there, and then, of course, make a determination if we're going to charge by warrant, if there's enough evidence to go forward at that point.
Charge by warrant, what does that mean?
We have a couple of choices, or police officers and prosecutors have a couple of choices. If there's a crime committed, the police officer can go to a magistrate, do a complaint alleging basically the basic facts around why this particular person is believed to have committed a particular crime, and a magistrate can issue an arrest warrant. And then the officer can go out and execute that warrant, pick that person up, and start the process that way. The other way that we have available to us is that 3 or more times a year we have a meeting of a grand jury, and a prosecutor can elect to take that case directly to the grand jury and never do the warrant.
So you would have, if you felt like you need to make an arrest, the person is dangerous or is likely to flee, you would have them arrested.
Absolutely.
And then there would be some kind of a hearing to see if they're entitled to have bond. Now, in the United States and in West Virginia, someone accused of a crime is allowed to post bond to guarantee that they will, A, be on their good behavior, and B, appear in court for the next proceedings. And the magistrate sets that bond, and it can be low if the person is known to be of good reputation, solid in the community, who has just had some kind of misadventure that results in a criminal charge, or it might be quite high if the magistrate, who is a judge, is concerned about the person showing up, about the person running off, or about the person being violent or criminal again in their behavior. And there are ways to have that reviewed. But let's say then the person is arrested and is put in jail, and it's a very serious crime, they're not able to post bail. What's the next step then?
The next step would be the fact that they'd be entitled to what's called a preliminary hearing, which if someone's incarcerated and can't make bond, should be held within 10 days of their arrest. And basically the purpose of that is to guarantee their right to have the state, the prosecutor's office, and the police demonstrate that there's at least probable cause to believe that that particular person who's charged actually did the crime.
We're talking about the role and function of a prosecuting attorney. My guest is Attorney Patrick N. Wilson, the prosecuting attorney of Marion County, West Virginia. I'm Dan Ringer, and this is The Law Works. So as I understand it, basically the preliminary hearing is to determine that a crime has probably been committed, and this person that's sitting here probably is the one who committed it.
Absolutely, in order to give them the opportunity to make a showing that they should not remain incarcerated beyond that point if there's not enough evidence to justify it.
Okay. So the next step then in the process, and we say that that person has been bound over to the grand jury at the end of the preliminary hearing if he's probably the one who committed the crime.
Yes.
So what's the next step then after that?
The next step after that would be, obviously, we communicate with defense attorneys. By that time, almost everyone who's charged has someone appointed or has hired someone to represent them. And we communicate to see if there's going to be some way to resolve that bound over case short of an indictment.
But how could you resolve a case short of an indictment?
There is, in many cases, a situation where they can be resolved by an agreement between the defense attorney, the defendant, and the state, typically referred to as plea agreements.
You plea bargain.
We do plea bargain.
You let these people off with next to nothing instead of prosecuting them to the full extent of the law?
You know, that's not the first time I've ever heard that.
I would bet that it's not.
We do have lots of occasions where cases are resolved short of a trial. And to be honest, as most of my colleagues in the prosecutor's offices know, the majority of cases are resolved without an actual jury trial. Lots of reasons for that, of course.
I've been an attorney for a bit more than 33 years now. Virtually all of that time doing some degree of trial work, and I've probably tried, well, I know I've tried dozens of cases, but we have resolved hundreds of cases and hundreds of cases through plea negotiations. How does that work?
Well, and again, the basis, I guess, that we have to think about is the fact that if we tried every case in every county in every state in the United States, the court system would completely fail. What I look at, and I think most prosecutors look at when it comes time to decide whether a case can be resolved short of a trial, is how good the evidence is, for example, in a particular case. How the prior record of the individual that we're looking at, is it their first offense? How serious is the offense? How good of witnesses do you have in terms of their ability to testify at a case, in front of a trial? Just a lot of factors which we look at and try to, the feelings of the family of the victims or the victims themselves, the thoughts of the police officers. We try to take all those things in account to decide whether or not this is a case that will resolve short of a trial or a case that's going to go all the way through the jury process.
One of the types of cases that I have seen many, many times, I saw it as a prosecutor, I've seen it many times as a defense attorney, is the embezzlement case. Invariably, on your first contact with the victim of the crime, they're very angry, they're very hurt, they feel violated, and they want their pound of flesh. They want the nefarious miscreant who committed that crime to go to prison for at least long enough to drive home the point that you're not going to do this anymore, or you're not going to do it to me. But the question I have always asked, whether it was a prosecutor or a defendant, is, do you want to see the defendant go to prison, or do you want your money back? And they will look at you confused and say, why is it either or? And I have to explain, if that person is out of prison, they will be able to find some kind of employment, make some kind of money out of which you can be paid some or all of your losses. If we put them in prison, you're not going to get anything at all until they get out. Your choice, and you know what the answer invariably is.
Yeah, absolutely. Most people are interested in getting their money back, and you know, I understand that, because what I've seen too is a lot of these people who are the victims of embezzlement are people who had established a very close relationship with the person who took the money, and after they get over that initial anger that you're talking about, then there's sort of a remembrance of, well, you know, not only would I like my money back, but perhaps, you know, this person deserves a chance.
Well, let's assume that you can't work out a plea agreement or choose not to try, because some cases are so serious that at that point you're just not going to try much to resolve them. A murder case, unless the defendant's willing to plead guilty to first-degree murder, there's not much motivation for a prosecutor to try to negotiate the case. So you go then to the grand jury. What's the grand jury process about? What are you trying to do there?
Well, again, it's a protection for people who are charged with crimes. In West Virginia, I'm not, as a prosecutor, allowed to proceed to a jury trial unless a grand jury has returned an indictment. And very shortly, what that means is that 16 citizens are picked to listen to the cases that the state presents against a particular individual or individuals, and they make a determination, basically hearing the evidence from one side. If they heard this evidence and there was no contradictory evidence from the defense, if just based upon what the state presented to them, do they feel that justifies a trial or would result in a conviction, then they vote and say that this person is indicted.
So that's a bit higher standard. At the preliminary hearing, you probably committed a crime. At the grand jury, the evidence against you is strong enough that if you don't have some way of defending yourself, you would be convicted, you're indicted, and then of course you go to a jury trial where the standard is beyond a reasonable doubt.
Yes, sir.
And that's the highest standard in the system.
It is, and as I've indicated for many years, I believe in that standard because obviously, particularly in these serious cases, I mean, we're looking at taking away a person's liberty potentially for life, like in the murder case that you were talking about earlier. So I think it should be a high standard. But quite honestly, if you have a case and the evidence is presented appropriately and the evidence is there, you can do it.
Did O.J. do it?
The jury said he did not do it, and therefore he's innocent.
Did Casey Anthony do it?
Again, the jury said Casey Anthony did not do it.
If you weren't there, you really don't know.
Absolutely true.
Pat Wilson, thank you very much for joining us.
Thank you very much for giving me the opportunity to be here.
Thank you also for joining us on behalf of the LawWorks. I'm Dan Ringer. Good evening. On the LawWorks website at thelawworks.org, you'll find a listing of recent The LawWorks programs, additional information about this show's topic, and video of this and recent shows. You can also find the LawWorks programs on YouTube and iTunes. If you would like to suggest a topic for a future The LawWorks show, or if you're a school teacher and would like to receive a DVD of this show for classroom use, send us email at thelawworks@comcast.net or visit us on Facebook.
The LawWorks is produced in cooperation with the West Virginia Bar Foundation, the Mountain State Bar, the Monongalia County Bar Association, and the West Virginia University College of Law. The LawWorks is made possible by a major grant from the West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and legal system, promoting public knowledge of the law in West Virginia. By the generous support of Software Systems Incorporated, a West Virginia company established in 1975, providing high-end support services, programming, and consulting for county government AS400 mid-range computer systems, as well as PC-based systems. And by viewers like you.
From West Virginia Public Broadcasting.